I will turn it over to our presenters to get us started here.
Thanks very much, Amy. And hi, everyone. My name is Ben Rothstein. With me is my partner, Rachael Meny, and our very talented associates, Luke Apfeld and Amy Phillip. We've all had a lot of experience recently working on, for some of us dating back many years, working on trade secret law, which is becoming more and more a hot area of IP litigation in our experience. And so we wanted to present to all of you on a few important topics that are related to preparing for a potential trade secret lawsuit in this day and age. And so our agenda today, we're going to give a brief overview of trade secrets, what is a trade secret, and what types of information qualifies for trade secret protection. We're going to provide some practical advice based on our case experiences and the current state of the law on how to protect trade secrets and prevent misappropriation. We're going to provide some practical advice on how to identify trade secret theft that's occurred. And then we're going to talk about a few very interesting topics that are sort of newly arising in trade secret law based on the current state of technology. So I'll hop now into our trade secret overview. And next slide, please. What is a trade secret? So I'm sure there are a lot of folks who are participating in this Zoom who know what a trade secret is, but just the basics first. And the first element is really two different things combined. A trade secret is information that is not generally known, but it's also information where the owner gets some kind of economic value from the fact that the information is not generally known. So it has to be a secret that derives value from its secrecy. The second element is that the information can't be readily ascertainable by proper means. So it can't be something that would be easy for your competitor to figure out on their own. And the reason why this is in brackets in this slide is because this is part of the definition of a trade secret under the Uniform Trade Secret Act and under the Federal Defend Trade Secrets Act. But in California, the legislature has omitted this from the definition of trade secrets. And so California courts sort of fold this into the inquiry of whether the information is generally known. And then the third element requires that the trade secret be subject to reasonable efforts to maintain secrecy. And that's, in many cases, that's not sort of where the action is on a trade secret misappropriation claim, but it is sometimes. And so if you're going to protect information by designating it as a trade secret rather than, for example, patenting it or in some other way, it's really important that you also take efforts to make sure that it stays secret by, for example, entering non-disclosure agreements if you're ever going to share the information outside of the company, making sure employees sign confidentiality agreements, or that you've got strong protocols internally to make sure that your information is secure. And we'll talk about a lot of those later on, but that's what the reasonable efforts to maintain secrecy goes to. And so there's obviously a lot of play in the joints with this language. It can be construed to cover a wide variety of business information, both on the technical and product side of a business, on the finance side, and on the sales and marketing side. So our next slide just provides a little bit of an overview of commonly asserted types of trade secret information. So some examples of trade secrets in the technical and product area can include, for a software and technology company, source code, which could either be lines of code or code files, or it could be the overarching structure of a code base, a database schema, or what are sometimes called entity relationship diagrams, algorithms, or even platform designs, which is particularly helpful in the case of internal facing interfaces and workflows. So, a lot of times a platform that, for example, a web-based company designs is not a trade secret because it's viewable to anybody in the public who visits a website or who uses the company's product. But sometimes companies design internal platforms for managing workflows that are internal only, and those you can assert are a trade secret, even just sort of the layout and how they look. For biotech and manufacturing, we often see information related to manufacturing processes. So a lot of times biotech companies will patent some of their IP, such as a particular molecule, but the process steps for how they actually create a medicine based on that molecule by growing it in yeast and smashing the yeast and so forth, that can be a trade secret that companies assert is something that's confidential to the company. Quality control processes, materials information, and so forth, those are all common trade secrets in biotech cases. On the finance side, a lot of times we see things like financial forecasts and information regarding investors or the company's capital table, particularly for early stage companies where this information isn't disclosed. On the sales and marketing side, companies have asserted trade secret protection over things like customer lists, and that can be a tricky one because in some industries, who your likely customers would be is self-evident, and anybody could gather that information. But in other industries, companies spend a lot of time figuring out who likely customers of their product would be, and they develop customer lists very carefully and very closely, and they keep those confidential. And so in those industries, customer lists can be a trade secret. Customer information, sort of information regarding which customers are the most important, what those customers' preferences are, when those customers' current contract terms are going to expire, and therefore those customers would become available for poaching from another company. Those things can all be confidential as well. Prices and pricing strategies can be confidential if they're subject to some kind of confidentiality obligation from the other side. But a lot of times in cases where prices are the trade secret, there's an argument from the other side that you can reverse engineer your competitors' prices just by talking to your customers and piecing together information about what the price you sell to them. And then lastly, business strategies, everything from product roadmaps to unreleased products, contracting strategies, sales and marketing strategies, how to deploy a sales force, how to penetrate a new market, all of those things, which are often found in sort of internal business slide decks, those can also be trade secrets and those often come up in the cases that we see. And so those are all sort of typical things that are I would guess, repeated sort of themes in trade secret cases and the types of information that are commonly subject to trade secret litigation. So we can move to the next slide now.
So I'm Rachael Meny, and I know a lot of the people on the Zoom, and it's nice to meet those of you that I don't know. So I'm a partner at Keker. I do a lot of trade secret litigation, but I also do a lot of investigations, and both when employees depart, but also when employees come in and they're accused of having brought information with them. Kind of the basic, standard employee mobility work. And what's important, what we see a lot is it's not the kind of standard trade secrets that Ben just showed the list on that are at issue, but whether you're losing an employee or you're gaining an employee, a key issue in a lot of those situations is the question of like, what can someone do who has been hired from a competitor with our company when they're working on a similar product? Where are the lines? And in particular, an issue that comes up a lot is if I've brought in somebody who's working on a product and they know that the company is going down the wrong path or spending money wastefully, are they allowed to tell us that? And how do we navigate that? And that is a very tricky issue. And it's a very tricky issue because of this concept of negative trade secrets, right? So negative trade secrets, it's very clear under the law that a trade secret can be knowledge that a certain technology or procedure does not work. So if you have an employee who's come across from a competitor and that competitor has spent a lot of time and money on figuring out how to do something and they know the right path, the idea that this is the right path or that something does not work is protectable as a trade secret under both California and the federal law. But it's also clear under trade secret law that employees' general skills, knowledge, and experience are not trade secrets, even if they've acquired that due to their employment. And so the trick in a lot of cases, and also in a lot of companies facing the question of like, what can former employees of my competitor do, is this question of where is the line on negative trade secrets? And this goes back all the way to 1965 in the Winston case, where the Ninth Circuit said, former employees can be enjoined from using knowledge of particular specifications of a former employee's machines, but they can't be expected to forget what not to do and how not to make the same mistakes in developing similar machines at a competitor company. And the question of how you balance those two standards is very tricky and unfortunately hasn't gotten much clearer since 1965. Next slide, please. So this was a big issue in the Waymo versus Uber case. It's a case that we worked on. And Judge Alsop in that trial ultimately allowed one allegation of an alleged negative trade secret to go to trial. And he issued a set of revised tentative jury instructions that had very long paragraphs about how employees are allowed to use the knowledge that they gained from their expertise and from prior employment, that is fair game. But what they're not allowed to do is take that next step further and use actual information from the prior employer. And you can see that tension in this jury instruction that he issued, where he says, you know, the results of extended research, if it proves that a certain process will not work, can qualify as an enforceable trade secret. But on the same time, negative know-how might not qualify in some instances if it's just a practical on-the-job insight, right? And so this is 2017, and it's still very close to the same standard that the Ninth Circuit was grappling with all the way back in 1965, and there's not a lot of clarity on that. Same thing in a case that we handled in front of Judge Alsop in the Genentech versus JHL case. Next slide, please. In that case, there was an argument at the injunction. And the plaintiffs were arguing basically, in that case, it was a situation where Genentech's trade secrets had gone to the new company. The new company argued that it wasn't using Genentech's trade secrets, that it basically had created a new product. And so they basically were arguing, well, since we're not using Genentech's secrets, you can't come after us on an injunction. And Judge Alsop said, well, look, that's not the standard. The question of whether you're actually using the trade secret is not the full standard here. If you've used the trade secret to save time, or you're using an improved version, you've used the product from Genentech to create an improved version, and then you've improved on it, that's still a way to get to a trade secret claim, right? So how do you balance these two things as a company, right? And especially when you're losing employees and you're worried that your employees are going to go to a competitor, but also when you're bringing employees in. The reality is, I would say that under kind of current trade secret law, the question of a negative trade secret, the question of whether your competitor is using information from an employee to kind of save time and fast track its product development is the murkiest area of trade secret law we face. You have the best argument that a negative trade secret case exists in situations where it's clear from the documents, it's that the employees have brought documents from the prior employer, and it's clear that those documents have made its way to the new system and been looked at by the next employer. That ends up being pretty great evidence in a negative trade secret case. You also can get to negative trade secret case where you have explicit communications and documents where the prior company is talking about the fact that X employee helped save time, or X employees suggested that we do something to help save time. If you can tie that employee to your company and what they worked on at your company, and the fact that they knew that you had done this product change, that can be very helpful in a negative trade secret case. And also oftentimes people are sloppy in emails. And so if a new employee comes in from a company, you know, they may say, hey, I think you can do this, and why don't you go down this path? And then the way that gets translated into emails is, you know, hey, we did this because so-and-so told me to do this, and he knows that from his prior company. And that can often show up in emails. And if you have that, you have a slam dunk negative trade secrets case. The trick is that, what do you do about the question of, like, when employees from a former company are much broader and just say, hey, why don't you try X, right? Or I know from my experience that X might be a route, or yeah, don't bother with this. And those are the situations where negative trade secret cases are really difficult, and where you end up in a fight about, is this prior expertise on the job, or is it like using the prior secrets? So what I would say about that is, you know, negative trade secrets is very important for people to consider as part of a potential trade secret case. It is also very difficult to prove. And so if you are a company that wants to bring a trade secret case, you need to know that you have an uphill battle on it. And if you're a company that is hiring from someone else, you want to do what you can to prevent a negative trade secret case. And so we're going to talk about that a little bit on onboarding. But one of the things you can do when you're hiring employees in to try to prevent a negative trade secret case is to instruct the employees not to share information explicitly about what they learned from prior companies. And so you can at least try to cut off these emails that sometimes exist where they're saying, hey, when I was at X company, we did it this way. And that makes it more difficult to prove a negative trade secrets case going forward.
Next, we're going to discuss some of the steps that companies can take to prevent trade secrets theft. Next slide, please. So the first step in preventing trade secret theft is to really get clear on what a trade secret is. And so to do that, I think it's worth briefly repeating the definition of a trade secret that Ben just walked us through. And that's that a trade secret is information that derives independent economic value from not being generally known, cannot be readily ascertained by proper means, and are the subject of reasonable efforts to maintain its secrecy. And so a key issue in litigation is often determining what information is actually a trade secret and whether that's been protected. And so that really relates to that third prong. So the steps that a company takes to proactively keep its trade secret information secret can really become a make or break issue. And identification of trade secrets isn't just important for the purposes of trade secret litigation, but it's also important to really proactively identify them so that employees are also aware of what information is being categorized as trade secrets so that they can take appropriate measures as well. And so that brings us to our next slide. It's critical to really identify what a trade secret is because it's more than just any sort of confidential information. And realistically, you can't protect all confidential company information as trade secret. So it's critical to really take time to define or know what your key trade secrets are, and then to identify any key areas of vulnerability in advance. And once you've done that, the focus really shifts to efforts that can be taken to protect trade secret information. Some of you might be familiar with Coca-Cola's protection of its Coca-Cola fancy formula. And that is sometimes the most kind of seen as the most extreme example of trade secret protection, but it really is a classic trade secret in the eyes of many judges and juries. And so I think it's helpful to kind of go through some of the steps that Coca-Cola took to keep its formula secret. So the Coca-Cola formula was kept in a bank vault in Atlanta, Georgia. The vault could only be opened by a resolution from the board of directors. Only 2 people at the company may know the formula at a given time, and their identities are protected. And they also cannot fly on a plane at the same time. And so, of course, we know that these somewhat extreme measures are not the only way to protect a trade secret, particularly in the modern age, but it really helps contextualize the importance of taking reasonable efforts to maintain secrecy.
Hi, everybody. I'm Luke. It's good to see you. I want to focus in a little bit on this third element, this reasonable effort standard, because that's where employers and corporations and companies can really hone in on what they're doing to protect and identify their trade secrets and set the stage for a strong trade secret defense or active litigation. So the reasonable effort standard, to start, this is the inquiry that the courts look into. And essentially, if a company doesn't do anything to protect its most valuable information, then how valuable is this information actually? Now, there's no one-size-fits-all reasonable efforts. What's reasonable for a 500-person company might be unreasonable for a 5-person company. The inquiry really comes down to, based on the resources available, the industry you're in, what are you doing to protect what you claim needs to be protected? So at a high level, some of the things that courts look to and some of the things that we advise our clients to implement are policies. But policies themselves aren't enough. You have to be able to train on those policies because a policy only goes so far as the employee's understanding of that policy. Next, and we'll get into these two issues a lot more later, onboarding and offboarding employees. These are the two instances where a company's actions can really shape future trade secret litigation. As a corporation, what are you doing when new employees come in? That's both affirmative and defensive. Are you making your employees aware of their obligations? Are you making your employees aware of the information that they will have access to? And are you clearly articulating what it is that you expect of them? On the other side, are you making clear that you as a company do not want any trade secret or confidential information from an incoming employee, and that they should be wary of their confidential obligations and cognizant to make sure to honor those? And on the other side of things, when you're offboarding, setting yourself up to make sure that you have done everything in your power to maintain the protection of the information a departing employee has had access to. You know, that's exit interviews, that's signed declarations affirming that property has been returned, documents have been returned, understanding where this employee may be moving. All of these sorts of things go into the offboarding process. And some other things that we think about when evaluating reasonable efforts are confidentiality agreements. How clearly do they articulate employee obligations? Like Amy talked about, what are the actual security measures employed around this trade secret information? Sometimes it's a physical barrier. Sometimes it's, dual authentication online. Sometimes it's limiting access to certain employees. And lastly, labeling, that goes in line with identifying the trade secrets. Do your employees incoming and departing actually know what your trade secrets are? I want to talk a little bit more about these policies and one specific type of policy in particular. So as I mentioned, confidentiality obligations must be clear. It's important here not to be too overbroad, because courts will determine that a confidentiality provision is overbroad. So clearly articulate what it is that your trade secret information is, and clearly articulate the obligations that your employee has, but don't do something like all information that you might ever touch at our company is a trade secret or confidential and therefore cannot be disclosed, because then you get into some murky water and it's unclear if that confidentiality clause will be upheld. A specific policy that we like to talk about is policies pertaining to company devices and applications. Limiting employee use to company devices and applications is extremely important. If you don't, there could be an argument that you waive privacy as to employer-issued devices. You want to make sure that an employee knows that they should conduct work on work devices and not mix the work and personal devices, as we'll talk about a little bit. But the policy itself is not enough. You have to enforce, not allowing personal email use or emailing work email back and forth from personal emails to company emails. The merging of online Dropboxes or cloud applications. If use of a personal device is allowed, ensuring that employees don't delete any corporate data on their personal devices when they leave. And for policies, they must be updated regularly. You have to review them consistently. Companies change, the law changes, so outdated policies may not have as much effect as a new and updated policy. And the last point here regarding policies is trade secret protection starts at the top and works its way down. Excuse me. The trade secret obligations of the senior most employee should be the same as the junior most employee. All employees must be apprised of company policies. And importantly, employees should know who to go to when they have questions about trade secrets, policies, use of material, etc. If there's no outlet to answer these questions, leaving trade secret interpretation and the use of trade secrets to the employee's discretion can get you into some murky water. Next, we want to talk a little bit about training. Like I said, and policy is only as good as an employee's understanding of that policy. So regularly repeat training, repeat the confidentiality obligations, and remind employees what their obligations are at work. Track progress, whether it's certifications that an employee has completed a training, whether it's an annual or every 6 months, a reissuance of kind of the confidentiality obligations. Make sure to track compliance with that, so that if you find yourself in trade secret litigation, you can say this employee knew that they had these obligations, and they affirmed those obligations repeatedly. And also consider what changes. If you're working on an outdated product and your information changes or your trade secrets change, that may change necessarily how you treat certain information. All of this can be accomplished through training. And lastly, before I hand it off to Rachel, just be careful about who you're disclosing information to. We live in an ever intertwined world. We have business partners, investors, regulatory agencies. Just understand what you're disclosing and to whom you're disclosing that information. If an NDA has a specific time limit, be aware of the NDA's time limit. If you're interviewing candidates and asking them to perform some sort of exercise to determine their candidacy, be aware of what you're disclosing and whether or not you may be waiving that trade secret protection by disclosing something more broadly.
So I'm going to cover some onboarding things. I'm going to go through this relatively quickly and just hit the highlights, because I think a lot of companies do a relatively good job of this, but I want to point out a couple of different issues that are very specific to what we need to do for purposes of like preparing for litigation and litigation. So first of all, Luke, can you just show the full checklist? This checklist here is the minimum requirement of what you need to have in place in the event you ever get a threat related to an employee that you've hired, or in the event that you ever have like a trade secret case that gets filed against you. This is kind of the bare minimum of what you need to do, and it's the best practices. It also, I think, is important to have these systems in place because it really sets the tone of a company regarding how they treat trade secrets and how they expect their employees to treat trade secrets. And that is important in both, helping to protect your company from trade secrets coming inadvertently across, or people in your company inadvertently asking others to disclose trade secrets. And it's also important if you're in the situation where you're ever defending against a trade secret claim. So I'll give some more detail on some of these, but this is kind of the key list. Next slide. So for onboarding, there's really 4 key areas that are at a minimum that you need to be thinking about. First is the question of high-risk hires, right? And for high-risk hires, you need to define who is a high-risk hire for your company and who is a high-risk departing candidate for your company. Sometimes at certain companies, that's a certain product area. At certain companies, that's a specific team. At certain companies, it's a specific level of employee. Whatever that is for your company, you want to know who is a high-risk hire or departing employee, and you want to think about onboarding practices, and we'll talk about this later, offboarding practices for that set of employees. And you may want to do something extra with respect to them than you do with respect to other employees. The same is true with interviews. That is a key area, and really a very key area in trade secret litigation, where information often gets inadvertently shared one direction or the other. And so you need to think about being careful with interviews if that's not something that your company already thinks about. And then the other place where companies really get tripped up, and we'll talk about this a little bit more detail in a second, is making sure that as people are coming into your company, you are confirming that they do not have any information and they did not bring it with them across. So next slide. One definition of high risk that I just want to flag is that pay particular attention if you're a California company and you're hiring an out-of-state employee, because everyone in California is used to operating in this world in which non-competes don't apply. And that may change at some point. It is slowly getting better across the country, but it is not consistent across the country yet. And different restrictions will be required for employees that are coming from outside of California than for people that are inside of California. And you want to know if somebody is coming from out of state, if they have any restrictions, and you'd ideally like to know that before you ever bring them into the doors of your company. Next slide. The other thing is, even for California employees, especially when they are senior, think about whether they might be subject to non-compete or other restrictions in non-employment agreements. So think about, for senior candidates, stock agreement provisions, acquisition agreement provisions, choice of law provisions, that kind of thing. California actually now has Labor Code 925, which allows companies to have employees sign an out-of-state choice of law provision as long as they are represented by a lawyer. So you can have California employees who have agreed that they will litigate or be subject to Delaware non-compete law, for instance. It is pretty rare, and it's very rare that a company actually takes the steps to have those employees represented by a lawyer in that situation, but we have seen that come up, and you need to pay attention to that even for California employees. Interviews are a huge area of risk for companies, and a huge area that companies often don't think about. Even if you don't do this for every single candidate, you should think about doing this for high-risk hires, which is you should think about training your interviewers on best practices for those high-risk hires. And that's because in trade secret cases, what often gets disclosed are the notes that are done after a candidate interviews about what the candidate talked about, the questions they were asked, and the types of topics they covered. And in deposition, you're always asked what you talked about during the interviews. So you want to train and encourage good interview techniques to prevent information from being inadvertently disclosed to your company. It's also a good way for somebody who may be joining your company to make sure that they understand before they ever walk in the door that your company doesn't want trade secret or confidential information from another employer. And it's a really important way to make sure that you're not creating really bad evidence in a trade secret case that will be used against you in the future. So, make sure that people are not asked questions that are specific to the work that they're doing at their prior company, especially if it's a key competitor. Make sure interviewers know that they are not to give details. And if interviewer starts to be chatty on details, shut them down. And then make sure that people who are writing comments about the interview feedback don't put in things about why this candidate's prior experience is going to be so valuable or useful to your company going forward. Next slide. For every candidate, but especially for high-risk candidates, it's really important to confirm that they're not bringing information in. Most companies now, when employees come in the door, have them sign a document that says, and often it's part of their employment agreement, sometimes it's part of their offer letter, saying, I don't have any information from my prior company and I'm not going to use it. I would say that for high-risk candidates or employees from a competitor, that may not be enough. And you may want to take some extra steps to ensure that information is not coming across. We're going to talk about cloud computing, but this is particularly important, I think, in a world of where people can put things in the cloud, because often what happens is if an employee at another company has uploaded information to a cloud and then they walk into your company, they can download it to your system, or they can download it and use it on their private accounts, and you will never know that they are using it, right? And so being sure that you are vigilant and you are talking to people before they ever walk in your door, or as soon as they walk in the door, about you don't have anything in personal email, you don't have anything from your prior company in Google Drive, Dropbox, any of those things is a really important thing to do, and get them to sign something saying they haven't done it, because that can be a key piece of evidence in trade secret litigation that will protect the company. Luke?
A lot of the same kind of principles and theories that Rachel just talked about in regards to onboarding also apply to offboarding. Essentially, you want to be thorough, you want to be diligent, and you want to have full knowledge of the world of information and movement that might impact you. So first up, be timely. As soon as an employee leaves, particularly if they're a high-risk employee, make sure that access to internal systems, to accounts, to databases is cut off. That way, it eliminates any ability that that employee has to access trade secrets or other confidential information after they depart. Also, immediately retrieve or seek the device or devices that the employee used from the company while they were there. Once you get that device back, make sure to log the timeline of that, the receipt of the device. And also, just as you would have kind of a checklist when onboarding an employee, have a checklist for exit procedures as well, right? Ideally, you would have something where each department that is involved in an employee's departure has to sign a certification or sign a form that indicates, you know, I've received the computer, I've conducted an exit interview. The employee confirmed that they do not have any documents in their possession. That way, all of the steps have been checked off and all of the departments are looped in to an employee's exit. A lot of times you see instances where an employee leaves and no one group or no one person is actually charged with that employee's exit, and therefore things can get lost in communication and nobody knows if material has been protected accordingly. I mentioned the exit interview earlier, and I think especially in the context of high-risk employees, an exit interview is super important. Not only can you do the document preservation and the return of the devices, but you can also get a glimpse into the motives of the departing employee. Why are they leaving? Are they leaving on bad terms? Are they going to a competitor? Anything that might raise suspicion that trade secret misappropriation is more likely than not, that can all happen through an exit interview. And finally, remind departing employees of their obligations that they signed in writing at the outset of their employment, that they received training on throughout the course of their employment, and make sure that you get a signed acknowledgement that they will continue to adhere to those obligations. And while you're offboarding, like I said, in the exit interview process, sorry, look for signs of misappropriation. Look for signs that an employee might take information with them, or that employee might continue to have access to information on a personal device. Follow up if you don't immediately retrieve documents and equipment. And make sure that you preserve anything of the employees that you do receive, whether it's the computer, whether it's documents, whether it's notes. Preserve those so that you can evaluate them if trade secret litigation arises. Ben, I think you're on mute.
I sure am. Sorry about that. So we've talked a little bit through the onboarding process and the offboarding process. And now I want to talk a little bit about what happens if somebody's left the company and you begin to suspect that there's been trade secret misappropriation. And so a lot of the initial telltale signs, Luke, you can go to the next slide. A lot of the initial telltale signs are similar things to what you would be considering in the context of a high-risk employee. So that's something that Luke mentioned a couple slides ago. What is a high-risk employee? There are some types of employee departures where the risk of trade secret misappropriation is already high just based on some basic circumstances. One would be if the employee is a particularly senior level executive or an engineer, someone that had access to and use of a lot of the company's core trade secret information before they left. Another is somebody who's leaving on bad terms, leaving to go to a competitor that's doing something directly competitive. An important part of the exit interview process will be trying to figure out, if you can, where somebody leaving is going. Are they going to your direct competitor? That's very useful to know in terms of figuring out whether and how far you want to push to do an investigation of potential trade secret misappropriation, maybe even before they leave. Are they terminated involuntarily, either as a result of layoffs and downsizing or other words? And then most of all, if they go to a competitor, and you find out they go to a competitor, are there other suspicious circumstances, right? Did they block their former boss at your company on LinkedIn? And did you find out that they went to a competitor sort of through other channels? Maybe they're acting surreptitiously in that way. Did the competitor come out with a very competitive product really quickly right after they joined? That's another telltale sign. So these are sort of circumstantial indicia, both the circumstance of the departure and then sort of what happens when they join a competitor. They could lead you to conclude that there's been trade secret theft and could prompt you to begin an investigation. Next slide, please. So the initial part of the investigation, when you try to confirm your suspicions, it's usually going to be some type of forensic investigation. You want to start taking a look at the paper, I'll call it a paper trail, but it's really more of a digital trail that an employee leaves when they go out the door. And a lot of times companies will do this on their own. But we recommend engaging a forensic investigator and outside counsel to assist in this process to make sure that in the course of conducting it yourself, you're not destroying any forensic evidence that you might want to later rely on or contaminating it in some way. And also, to the extent you reach out to the other side, to make sure you're doing it in a way that doesn't prejudice you later on. So some of the things you're typically going to be looking for are checking activity logs of any type of cloud-based service that the employee frequently used. So for example, if they're a software programmer and the company uses a service like GitLab or GitHub as a source code repository, the admin account might have access logs that will show when a particular employee accessed the code base. Did they download the whole code base to a local copy the night before they were fired? That's something that you can tell before you even reach out to the other side. Same thing if you use Google Drive. There's a feature called Google Takeout. One of the things we're seeing in a lot of these trade secret cases is that employees will do a takeout of their entire email and all the documents that have been shared with them through Google Drive and their entire calendar and all of their contacts by doing a takeout of all of the information that they have access to on all of those Google applications through their work account. Have they been emailing emails to their own personal email address shortly before leaving the company? One of the things you can do pretty easily is access the departed employee's email and run a search for their personal email address that they've provided to the HR department. Have they been sending themselves a bunch of email right before they left? That's useful to know. And then there's more advanced forensics too that you can do to see, for example, did they wipe logs on their return computer after they left? Did they use the USB ports to put an external device into the computer shortly before they left? All of these things you can tell. One of the critical things, though, is you need to have a forensically clean copy of the computer that the employee was using in order to do that type of investigation. If you want to look at the computer itself, you need the computer. And so one of the things that is really important to do, especially for a high-risk departure, is make sure that the employee returns their work-issued laptop or their work-issued computer before they leave the company, and specifically instruct them not to delete anything from that computer before they return it. Because you don't want a computer that's got a completely wiped hard drive, obviously. You want the computer sort of in the natural state in which it was being used right before the departure. And then the last thing, a lot of times companies reach out to the former employees, send a cease and desist letter, or reach out and demand the return of laptops if they haven't been returned yet. What a common misstep, and it's a really unfortunate misstep, is when companies in that initial outreach instruct the employee to certify that they've either returned or destroyed everything. That's almost like a get out of jail free card for an employee that's stolen trade secrets, is if you instruct them in the first outreach to destroy. They will immediately contact a lawyer, and the lawyer will tell them, you've received the get out of jail free card. The get out of jail free card is the letter that instructs you to now destroy all of the evidence that you exfiltrated, all the documents. Lucky you, you win. You're really lucky. Now go ahead and do exactly what they told you to do, which is erase all of the files that you exfiltrated and all of the forensic data that will show whether you were accessing them after you left the company. So that's just one example of why it is important in this situation to engage outside counsel, because they can help guide you and make sure that in the initial outreach, you're not making any missteps that could prejudice you later on. And next slide, and I'm turning back to Rachel.
Yep. Prior slide, please. So one reason it's really important to identify kind of high-risk employees or high-risk areas for your company, whether they're incoming or outgoing, is the idea that you've got to act promptly on this stuff, right? it happens all the time that somebody will call us and they'll say, hey, I have a concern about this employee, but it turns out that they've had that concern for 6 months. And there's been a series of things that have required it to bubble up. And it finally gets to the point where you reach out to outside counsel. The problem with that is by that point in time, often their email is no longer available. Their access to cloud accounts is no longer available. Maybe their laptop's no longer available. So acting promptly when you have suspicions is the best way to ensure that you get what you need to be able to figure out what is the best way to protect the company. The other piece of this that's really important to think about at an early stage is if you are doing an investigation, you want to make sure that you are maintaining privilege over that investigation for as long as possible and as much as possible. So you don't want to be bringing people into the investigation who don't have a need to know. You don't want to be like alerting business people to the situation and then allowing them to talk about it without a lawyer on the email. It's really important to take the steps to maintain privilege from the very beginning. Because otherwise what often will happen is you will end up seeing emails from like business people who know about it, who then say, oh, well, that trade secret didn't really matter, or that piece of information didn't really matter, or it's publicly known. And all of that evidence is bad. So if you are investigating something, maintain privilege, keep it need to know, and be strict with that. And then obviously, preserve what is needed, interview your witnesses. And then the last thing is really a strategy call. At the point in time at which you send a letter, you're basically making a choice of like, do I have enough to litigate or do I want to send a letter? And if you're sending a letter, as Ben says, do not give them the get out of jail free card of telling them to delete documents. You don't always have to tell them to preserve documents if you don't think that the evidence is quite enough there, but you do want them to respond to you. You want them to certify that they don't have information. And if they come back to you and say they have information, then you want to figure out how to deal with that. Next slide. Lastly, these are pretty obvious, but the last one I want to talk through quickly, issue lit holds at the appropriate time. Consider who will testify, but importantly, consider who will give evidence of your misappropriation, right? As Ben said, we recommend often using an outside forensic vendor. And the reason for that is because if you use somebody who is inside, that person is often been exposed to the investigation, right? And if you put that person in as your witness in a trade secret case, you can waive privilege inadvertently in that situation. So you need to think very carefully about who is it going to give evidence of misappropriation. If it's going to be an inside person, they need to be cabined off from the investigation. And the safest way is to use an outside person. And then lastly, one choice is obviously always referring matters to law enforcement. That is a strategic decision that you want to make with outside counsel. There are real benefits to it, especially in situations where you're worried that the information is going to leave the United States. They have tools that civil lawyers don't have, and they can move a lot faster than civil lawyers can do. But they are also slow. You have to get them interested in it, which takes often going and presenting evidence. You have to have your whole case basically together before you reach out to them in most situations. And you often end up having to disclose trade secrets to them. So it's a very careful decision to make, but it is a powerful tool in these situations.
All right, next we're going to talk a little bit about new and emerging issues in trade secret law based on changes in the industry. Next slide, please. So we're going to discuss the impact of recent technological changes, workplace shifts, and legal changes that present new risks for companies. And we're also going to discuss specific measures that companies can take to get ahead of these risks. And so some of the topics we're going to talk about include the exponential increase in ways to transfer data, specifically through cloud computing, the massive increase in work from home and the use of personal devices and bring your own device policies, the increased use of AI in the workplace, and challenges to confidentiality provisions. So I think a case study that really highlights the cloud computing issue that folks have referred to earlier is a recent indictment of a former Google software engineer who was indicted on 7 counts of trade secret theft by a federal grand jury in San Francisco. The former employee had uploaded over 1,000 confidential files to his personal Google Cloud account between May 2022 and May 2023, which included a lot of trade secret information related to Google's AI. The indictment alleges that Mr. Ding, the former employee, had intended to benefit 2 Chinese AI technology companies by stealing trade secrets from Google related to the hardware infrastructure and software platform that allows Google's data center to train and serve its large AI models. And this example really highlights how cloud computing can aid in trade secret theft, which we'll delve into more on the next slide, but also really the importance of implementing best practices specific to cloud computing issues to kind of be able to assess and track these earlier on. Next slide, please. Cloud-based computing makes it harder for companies to protect trade secrets because it makes it easier for employees to share confidential documents onto personal Google or iCloud accounts. It also makes it easier to create local copies or downloads with minimal tracking. So the ease of being able to transfer confidential documents, coupled with the increased use of personal devices for work, as well as the increase in companies taking on bring your own device policies, which Luke is going to talk about a little bit more, makes it harder to really track trade secret theft when it happens. And so it's really important to be mindful of practices to implement specific to this. Next slide, please. Another implication of cloud-based computing is that employees who inadvertently copy trade secret materials onto personal iCloud accounts through tools like automatic syncing may still be liable for misappropriation if that information ends up on devices or systems of a new employer. And so a classic fact pattern that this might come up in is if a senior employee is given permission to use their personal iCloud account credentials on a company-issued Mac, and then has instructions to save their work and personal materials into different folders. When that employee leaves to start working for a competitor, even if the employee attempts to delete all of the work files in their iCloud account and sync devices, it's very likely that the documents don't actually disappear, but instead just get moved onto a deleted items folder or something similar on iCloud. And so when that new employee logs into iCloud using his personal credentials on their new work computer, the full contents of his iCloud account might sync onto the new device, including that deleted items folder. And so just like that, his new employer now suddenly possesses a competitor's confidential materials, even if the employee had no idea that this had happened. Fact patterns like this have come up in trade secret litigation in the past few years, and both times have resulted in a very fact-intensive specific inquiry. In Apple v. Rivos and NDCal, the court's inquiry focused on whether the distribution of information in the cloud was automatic or if it was somehow triggered by actions that the defendant took. And it also focused on whether the defendant's new employer actually used the trade secret information. And then in CAE Integrated, the Fifth Circuit denied a preliminary injunction because the plaintiff couldn't prove that the defendant had actually accessed his Google Drive that contained plaintiff's previous trade secret information since joining his new employer. And so these both really highlight the importance of implementing best practices specific to cloud computing, which we're going to delve into on the next slide.
And if I can just say, Amy, I think both Ben and I see in basically every trade secret case we deal with now, cloud issues coming into effect and data being moved to cloud issues. And so it's really, really important to know how your company is addressing this, because they are the way that data is now being moved from one company to another.
Thanks, Rachel. Yes, it's so critical to assess exactly what existing cloud-related practices are in place, but then to also think about actions to take to specifically minimize that risk. And so that could look like requiring the use of company-issued Apple or Google accounts instead of allowing employees to use their personal accounts. and restricting outside the company cloud sharing of documents from those corporate Drive or iCloud systems. It could also look like implementing data loss prevention software, which would provide tools such as logging and alerts about data movements that might constitute exfiltration. And so when you think about the Google software engineer employee situation, for example, if perhaps better data loss prevention software had been in place, it might have been easier to kind of track that year-long movement of files. It's also important to use exit interviews to ask employees about files that exist on their personal devices or personal cloud storage systems, and to ask them to verify that they have searched and removed any existing documents, including deleting folders of deleted items. It's also important to, especially with particularly high-risk employees, when these employees are departing, to really examine data loss prevention tools and Google Workspace logging and things like Google Takeout that Ben mentioned, to really see if there are any patterns of potential exfiltration. And then finally, when hiring new employees, it's important to explicitly ask them to confirm that their cloud storage systems don't contain any third-party confidential information, and if so, to remove it before they begin.
We have a couple slides on personal devices here, and I want to give Ben a chance to talk about AI. So the upshot with personal devices, which we've seen an uptick in use in post-COVID, is essentially that courts may not deem allowing employees to use personal devices as reasonable trade secret protection. The thought is keep business work and business communication on business devices. Otherwise, if folks can use their personal devices, that may be deemed as failing to protect trade secrets. I'm going to skip ahead, and we can talk a little bit about trade secrets, Ben, or AI, Ben.
Sure. And I don't, this doesn't really reinvent the wheel, but I just want to give an example of a situation in which, and we've got a few case studies here. I'm not going to go through all of them. I just want to speak a little bit of a higher level, given our time constraints here. We all now probably, many of us, and certainly many of the employees of the companies where we work, routinely use AI services like ChatGPT or Claude to help us in our daily jobs. They're great resources for understanding new areas that we're working on or things like that. The risk to data loss and the risk to trade secret protection from those tools now comes in the form of copying and pasting something and entering it into an AI platform. And I'm ignoring for the moment like AI-driven cybersecurity things, which aren't really within the scope of like lawyer trade secret stuff. Obviously, you should all be working with your InfoSec teams to figure out the threats to your infrastructure based on new AI cybersecurity threats and figuring out what types of commercial InfoSec tools you need to protect yourself against those. I'm talking more about how employees might, interacting with AI services through the internet, might inadvertently lose protection over your trade secrets. So the way it would often happen is if somebody's using ChatGPT or something like that for a work-related purpose, and they enter information into the service in order to learn something, here, copy and paste a section of a contract, put it in ChatGPT. ChatGPT, can you please explain to me whether this contract does the following and which provision does it? You might think that you've anonymized it sufficiently so that ChatGPT doesn't know who the parties are or what the agreement is, but maybe you haven't, because ChatGPT is AI and it can triangulate through all sorts of different things. It learns algorithmically. And so anytime that you're entering something that's arguably confidential, or maybe even a part of something that's confidential, but not the whole thing, anytime you're entering it into an AI platform, you're creating an enormous risk that the trade secrets are going to be lost, that protection over them is going to be lost, that the AI will figure it out. And so AI in that sense should be viewed as just one of many additional vectors, just like cloud services, just like personal devices, as another vector for data loss and another thing that you need to protect against when you're taking reasonable efforts to protect your trade secrets. And so one of the things that we would recommend all companies do, just like companies more and more are having specific policies on not using personal cloud-based storage services for work purposes, don't access work documents using your personal Google Drive. Use your work Google Drive. Don't access work documents using your personal Dropbox account. Use your work issue Dropbox account. Don't, you can use your personal device for sending and receiving emails, but don't otherwise use it for work-related purposes. Use a company-issued device. Similarly, we recommend having policies saying whether and under what circumstances employees are permitted to use ChatGPT, Claude, or other types of AI services in connection with their work. Be clear. Warn employees, hey, you might think that it's okay to have a conversation with ChatGPT about something at work, but not if it's confidential. And if you have any doubts about that, speak to your manager, speak to legal, but don't make your own decision about it in an area of ambiguity, because you might not realize it, but that's a very, very easy way for us to lose control of our sensitive trade secret information.
And the one other thing on AI I just want to flag is we're starting to see cases about people who have used AI to record company meetings and whether those AI transcripts create issues with respect to trade secret protection. So as part of thinking about policies on AI, consider all uses of AI, right? Both ChatGPT, but also like AI recording, and think about how we do that. Because at any point in time at which information is uploaded to AI sources, that potentially creates a risk that somebody would later argue that you've not reasonably protected your trade secrets. And then it also obviously, creates a risk of potentially not great evidence or a lot more evidence being available in cases. So thank you all very much for your time. We really appreciate it. If you have questions, please, we can stick around for a couple of minutes if anybody has questions, and also always feel free to reach out to any of us